Mr. Murphy,
Good morning, Your Honor.
you may proceed.
Thank you. This is a situation where Mr. Robinson was arrested by the Brockton police as a result of them going to a Holiday Inn Express in the city of Brockton looking for an individual by the name of David Simpson in possession of a warrant for a Trammell Jackson. There was an AKA that purportedly matched up Mr. Simpson with Mr. Jackson. When they went to the hotel, they went to a particular room. As a result of going into that room, they met my client, Lonnie Robinson, another young lady who was with him, and they then took him out of the room. A search resulted sometime later where a pair of pants was found, and in the pair of pants was a package of cocaine that weighed between 14 and 28 grams. The process went, as the process generally goes, in Superior Court for several years. We came up on a motion hearing date in February of 2003. At that time, the case was continued by agreement due to availability of a witness. The case was then set on May 14th of 2003 for the motion to suppress, at which time Mr. Robinson failed to appear.
And he knew about that date?
He was aware of the May 14th date. That is correct, Your Honor.
Well, what's your position? Defendants get to decide when they're going to show up for the hearing?
No, Your Honor, that is not my position. My position is that balancing the equities in this situation, because Mr. Robinson is faced with a mandatory minimum 3-year sentence.
So speaking about equities, what was the reason he gave the judge for not failing or for failing to appear?
When he appeared a year later, Your Honor, he indicated that his girlfriend was having a baby at the time, and that is it was his desire to be with his girlfriend and the baby.
So a defendant could decide whether to show up or not based on their assessment of priorities. His girlfriend was going to have a baby. That's a good excuse.
Obviously, every individual makes choices, Your Honor. And is that a valid excuse for not showing up at court? No, that is not a valid
Well, why
excuse.
should the defendant be able to frustrate the court system? Why couldn't the judge just say, okay, Mr. Defendant, you know you're supposed to be here and you've decided to absent yourself. It's your motion. You've waived your right to be present at the hearing on your motion. We're now going to proceed with the hearing on the motion, because the Commonwealth has the burden to prove that whatever the search was appropriate. Why couldn't the court just not do what Judge Healy did here? Instead of just defaulting the defendant and denying the motion, why couldn't the court just go forward? Why should the defendant, because his girlfriend is having a baby, which is
Well, in fact, I asked Judge Healy to go forward, Your Honor, and he wouldn't go forward in absence of the defendant.
Okay, but so you agree that the judge could go forward in absence of the defendant?
That...
Well, why should your defendant be able to frustrate the court system, which goodness knows has a hard enough time keeping up with its caseload, and presumably the officers were there and ready to go?
I don't think it's a situation of frustrating the courts, Your Honor.
What did it do? It prevented the hearing from going forward that day.
It prevented a hearing from going forward that day. That is certainly the courts have very valuable time.
So why couldn't they have just gone forward? What would be wrong if the court had gone forward?
Put it this way. He has a constitutional right to be present, correct?
He does.
He can knowingly waive that right.
He can knowingly waive it, absolutely.
Well, he can waive the right if he knows that the hearing is going to take place, and if he doesn't make any proffer of, which would have to be supported, why he's not there. In other words, then the officers testify. It might be that effective cross-examination or whatever it is leads the judge to rule affirmatively on the defendant's motion. I don't know.
That could have happened, I would submit, because I would have gone forward based on Judge Healy's decision to waive his hearing. But
waive his presence.
Yes, but that was not a position Judge Healy was willing to.
No, but we're asking you what would have been wrong if Judge Healy had said, okay, the defendant filed this motion. He wants me to take the court's time to hear it. The witnesses are here at the Commonwealth's expense. The DA is prepared. we're going forward. He's waived his constitutional right to be present.
And you would have gone forward on
And
those
I would have gone
terms.
forward, sure.
That's what you're
I
saying.
would have, because it is my opinion.
So I'm saying, do you have any problem if we say that that's what should have been done?
But it wasn't done, so.
I understand that. I'm
I understand. I
asking you,
think you're
do
saying
you
You'd
have
have
a
to vacate it
problem?
and send it back, and you'd win. by
And have
sort
your-
of-
But I'm saying,
But you're
if
not
we
prepared to make
say,
representations on behalf of the entire defense bar.
Exactly.
in your case, if we were to say that the judge should have gone forward with the hearing in the absence of the defendant, do you have a problem with that?
Not when you ask.
Not in
The answer should
Mr.
be
Robinson's
no.
case. I would have been willing to do it in that manner, because I believe that there are so many issues with regard to what the police did based on the warrant, which was an unsigned warrant.
That's what I'm saying. There may be valid reasons
Right.
that have got absolutely nothing to do with the defendant taking the stand to testify.
And he would
I
not.
take it that if you want the defendant to take the stand to testify, which is not exactly a common occurrence, but if you wanted the defendant to do that, you would have pressed further as to why the hearing should not have proceeded, because the defendant had a valid, you would have told the judge what the valid reason was, correct?
Yes, but I don't want to go down, it seems to be a slippery slope, though, because if in every circumstance a lawyer's put in a position
I
where he
understand.
has to say, I am either going to lose the motion based on waiver, or I'm going to go forward in absence of the defendant, without necessarily knowing why a defendant is not present. So I think that puts a lawyer in a very untenable position.
I understand
Waiving
that.
certain
You haven't heard-
rights.
It puts the court in an untenable position as well, which is
But
obvious from this case.
I take it that you haven't, hypothetically, the hearing is scheduled for Tuesday morning, you have a conversation with your client on Monday, show up tomorrow, hear the directions of the court, client says, I'll be there. It is not your intention to call the defendant as a witness, but it is very helpful to have the defendant there who can perhaps make suggestions to you as to appropriate lines of inquiry for cross-examination or whatever. You are saying you haven't heard from your client, you had every reason to believe he or she would show up, and you don't want to be put into an untenable position, but it seems that you can preserve your right to say, I haven't heard, I'd like to, I may have to come in and file a motion, I'm willing to proceed, but if necessary, I'd like to, start all over again if there's some valid reason. It might have been that he was hit by a truck and in hospital someplace, right?
Correct.
But from a trial judge's perspective, it also might be that the defendant just decided, for whatever reason, not to appear, and it might be a waste of judicial time and resources and everything else, right?
Well, then you get to know.
Possibly. In my experience, what will happen is if somebody, I think your scenario, Justice Ireland, is that people are just going to leave and go on the lam for periods of time. I think generally most people wait until all of their motions are done and they're coming up on a trial date before they will bail out of the ship.
Or another scenario is they don't show up on the day the case is scheduled for hearing, but a day right after that, and they just wind up rescheduling it again and again and again, which can be very frustrating to the witnesses and the court system.
And he had, that was the other thing with Mr. Robinson. He had showed up on other dates when the motion was scheduled. So in Judge Healy's opinion, by him not showing up on that day, he was waiving his right to the hearing. People are informed of a lot of things. You've just been listening to arguments about bail revocations for 60 days. When an individual walks into court, they are informed that if they go out and they commit a new offense, the bail on the case that they were out on bail based on a new offense can be revoked. Nobody, in my experience of 18 years, has ever been told, hey, if you don't show up on date, May, let's use this date, May 14, 2003. If you don't show up on that date, your ability to go forward on your motion is going to be waived. Lots of rights are advised to people, but that is not one of the rights that courts advise people of. If you don't show up on your motion date, your motion is going to be waived.
Well, defendants are also not advised, I don't think, that maybe I'm wrong, that you've got to file your motion to suppress by X date, right?
They rely on
And if you don't,
lawyers,
you waive it.
right.
They rely on the lawyers. The lawyers say, well, we've got to file our motions. If we don't file them timely, they could be denied on that basis, right? We don't file a motion to suppress timely, the judge can deny it without getting to the merits. Whether your client has assented to the late filing or not, he can then probably bring a motion for a new trial based on ineffective assistance of counsel, but
practicalities are, you would advise your client he has a motion to suppress, and that the rules are it has to be filed by a certain date. Those rules generally can be fairly flexible. With regard to advising a client that if he doesn't show up on a motion date, that I think is a much more vague area as far as lawyers are concerned. I don't know that a lot of people actually realize that the motion can be waived if the defendant fails to appear.
Mr. Murphy, forgive me, I don't know this, but is there a transcript of the hearing before Judge Healy? I mean, I see his.
There was
Yes.
a transcript, yes.
And his explanation is?
His explanation was, the defendant's not here, his motion is waived.
Now, when you asked to go forward with the hearing, did he give you
No,
an
no.
explanation as to why you asked to go? I mean,
Actually, I don't think that appears in the transcript, to be honest with you, Your Honor. There is some discussion about me objecting to
the waiver.
the hearing,
yeah.
to the waiver of the motion hearing. But there was a dialogue with the clerk, obviously, that wasn't on the record about going forward and seeing if the judge would do it, and it didn't occur. But when you weigh the two things, the court's very valuable time versus what, in this case, I would submit to all of you is a very, very viable motion to suppress, grounded on strong constitutional issues. The balancing of the equities, well, the case law does say a court can consider it as a waiver. I'm submitting that Judge Healy committed an abuse of discretion in this circumstance based on, I mean, Mr. Robinson, at this point, without his motion, may as well just simply walk in and be found guilty.
So what you're suggesting is one of the criteria that the court should use in deciding whether to exercise its discretion is the merits of the underlying motion? Not just the reasons why the defendant wasn't there, for example, things of that.
I would submit, frankly, my position would be if a person fails to appear one time, not multiple times, but one time for motion, they should be afforded an opportunity to have that motion heard again. Because while one individual may think a constitutional issue is not very strong, another may think that same constitutional issue has significant merit. So
That may make sense before this case, but presumably if it's clear that not an automatic waiver, which was Justice Cowan's question, is it an automatic waiver? If not, but there's a possibility that if you don't show up, the judge is entitled to waive. I mean, every defense attorney is going to tell every criminal defendant, this is an important hearing. This is as important as, trial or, whatever it is.
well, that would, if the court were inclined to go down that road, that's certainly something every defense lawyer would have to now really focus on informing their client. If you have a motion to suppress scheduled for date X, you need to be there, otherwise your failure to appear would constitute a waiver.
Well, isn't that a
Mike.
condition of his bail?
Yeah.
Wasn't that a condition of his bail that he attend this hearing?
The condition of bail is that you appear for all court appearances, certainly.
And wouldn't
Including
that-
this one?
Including that one, yes.
And wouldn't that be a good result?
And his
why
bail was revoked, Your Honor, by the way.
And wouldn't that be a good result? I mean, why shouldn't the defendant be present? It's his motion. Why should he be able to prevent the orderly working of the court system? We have terrible delay in the criminal justice system, and one of the reasons is because half the time the defendants don't show up.
Frankly, I'm not a defendant, so I can't specifically speak for defendants, but people generally who are charged with crimes, I don't believe, in my experience, are going out of their way to cause the court some difficulty by failing to appear.
I understand that, but
they're
they are.
afraid, they're just not knowledgeable enough to realize the impact that their failure to appear would have.
And what about their victims who are coming to court and also being put through the trauma each time that the case is scheduled and that the defendant just doesn't realize that it's important to show up?
I think that's a different situation where you have a victim. Generally, if a person defaults...
But the rule, we
that-
make a rule, it has to apply across the board. We can't make a rule for some defendants and not for other defendants.
Well, that's what discretion's all about, and that's why the individual facts of each case has to be considered, it seems to me. But in this case, I mean, I take it that he appeared before, and the Commonwealth wasn't ready.
Appeared
They asked
in
for a
the first.
continuance. So, the people weren't ready. They asked for a continuance. He didn't appear the second time. And the question is, how's the judge, what are the range of tools the judge has to deal with that, and how should he exercise his discretion? Because he clearly has discretion to take some action.
He does. I'm just suggesting that because these are strongly founded constitutional rights, that in this circumstance, it was an abuse of discretion on the part of Judge Healy to waive it, because Mr. Robinson is basically left in a situation where there is not much to try in his case, based on what I would submit is an illegal search and seizure.
Thank you, Mr. Murphy.
Thank you.
Ms. Burbine?
May it please the Court, Carolyn Burbine for the Commonwealth. It's our position that the judge properly exercised its discretion.
How can we accept your position? Because if the defendant, his motion is automatically denied, he goes to trial, therefore his defense counsel says he has nothing left to try, he's found guilty, comes up on appeal, don't we have to rule that if the defendant's correct, that he has a very good constitutional issue, don't we have to rule that it's an invalid conviction?
Well, first of all, we're not arguing for automatic waiver. We're saying the judge has the discretion and that the criteria should be. But the criteria we say should not be. What does the judge have in front of him? He has just the defendant's untested preliminary facts.
In this case, if we adopt your position and uphold the judge's action, then there'll be a conviction, and then it will come up on appeal, and there'll be an argument that this was unconstitutional, and if the defendant is correct, we'll have to reverse.
I don't know that it's a given that he'll be convicted, and also I also believe that.
Well, assume the defendant has conceded.
But it was his. I think the defendant has to be held to his choice. He chose not to appear.
Okay, so then what happens down the road?
What happens down the road is that the judge had the discretion to deem this waived. We go to trial. If the defendant is convicted, he appeals, and we reverse.
Ms. Burbine,
Well, not necessarily. I mean, it's waived.
Let me suggest something here, and I don't wish to put the defense attorney on the spot, and I don't intend to, Mr. Murphy, but we've had a fair representation by this defense attorney that, as a general matter, it has not been, at least his experience, that the failure of a defendant to show up one time resulted in a waiver of the motion. I may be permitted to infer from that I would receive, or a court would receive, an affidavit from defense counsel saying, I wasn't told this by my defense attorney, and had I been told this, I would have put this ahead of the birth of the child of whom I'm the father, assuming that he's the father. He's a girlfriend's child. That's an ineffective assistance of counsel claim. So the question here is, what do we do in this case, and what guidance do we provide, both to trial judges? Is it an automatic waiver, as Justice Cowen asked? In other words, you don't go into what are the reasons. You are told. I mean, you can move for a continuance if defense counsel knows, that the person has been, hospitalized or something. Otherwise, it'll be a waiver. Or the defendant can elect to proceed, and as a general matter, the judge should take whatever evidence the Commonwealth is prepared to admit and have the defense attorney cross-examine, isn't it?
Well, I still think we have to go on the fact that the defendant had notice. He knew the date of the hearing, and he chose not to show up. So by not showing up, it's effectively the same as if he had walked into the courtroom and said, I've decided I'm forfeiting my motion. I don't want to go forward on this. And that's how it should be. The judge should have the discretion when he looks at what I set forth as what we believe the criteria should be. Did he deliberately give up his opportunity to have his motion heard? And here he did. It was filed for his benefit.
Excuse me,
I'm sorry.
do you agree with Mr. Murphy that there was a request that the judge proceed with the hearing in the absence of the defendant?
I don't know if that happened, Your Honor. I understand Mr. Murphy says there's a transcript. I don't have a transcript of the hearing, and I looked at the docket, and it doesn't say that a hearing was held, so I'm not sure.
Well, we know that counsel objected to the ruling of waiver. Let's assume for a moment that if the judge had said, well, I'll allow it to go forward today without a waiver, but the defendant has waived his presence. I assume counsel is saying I would have been ready to go forward on that basis. Let's not get caught up in what the
Yeah.
Somebody suggests this already, but your position is going to create multiple issues on appeal. I mean, that you do have something from the defendant with these motions. You can't file one of these things unless he files a written affidavit, correct? Under penalties of perjury?
I don't think there's an affidavit from him on the motion for reconsideration.
Well, the rule requires one. That's a different issue. So 98% of the cases you're going to have, 99% of the cases you're going to have, they're going to, say flat out that the search, the Miranda, whatever it is wrong because they were drunk, they didn't understand the warnings, they were mentally ill, the police, before knocking and announcing, barged through the door. You know how it goes. The appellate court's going to look at this and say, how can we tell on this record whether this motion had merit or no merit, because the judge just said it's been waived. So it's going to be remanded back for a hearing. So you're arguing for a position that is, it seems to me, to be very impractical.
But I think
on the other hand, though, if the rule is that defendants can always be heard on this, what do we do when the defense counsel says, I'm prepared to go forward in the absence of my client, but my client has a lot of good information that would really resolve the motion?
then that's why I don't think it's real. I don't think the judge should go forward with it.
He's not here. Swear in the police officer, and we're going to hold a hearing right now.
In other words, it's not a waiver of the motion, it's a waiver to be present at the motion.
Correct.
Well, but if you look at Espinosa and McVicker, they're saying it's a waiver of the motion by the defendant. In effect, he's gone in and said, I'm not going forward on this. I've decided by my I'm not showing up and I'm not going forward is the essence of it.
If neither the defendant nor the defense attorney shows up, but the defense attorney is the defendant's agent, and the defense attorney is saying, I'm prepared to go forward.
But then you'll have an issue. What if the defendant then comes back and says, but I wanted to testify, and you went forward, and I didn't get my chance to testify? And
That's waived.
That's waived.
It's like a trial.
But I don't think you can go forward if, I think
Why? We
it
can
has
go forward
to be
at
that.
trial without the defendant if
I
he's
think-
not
Skips in
there.
the middle of
Right,
a
but
trial.
that's another example of how there are times when the defendant's actions have led his rights, he has waived
Right,
his
but we
right.
don't stop the trial and
So-
convict the defendant because he
No,
absconded.
but in
and we
Fleming, he
continue
was
with the trial.
there in the beginning, and wasn't there, and the court said, okay, now you've waived your right, you can't come back now and complain.
Well, if he's not there at
And-
the beginning, then he's defaulted, as he, I
Right,
think, I
but
assume was here,
here-
and a warrant is issued for his arrest.
But here in the motion to suppress, I mean, supposedly, and I don't want to go outside the record, but our grand jury minutes are not indicative of a strong case for the defendant. But I, obviously couldn't put that information in here because I'm limited by the record. But I think it has to be the criteria that we set forth. Did he, by his actions, default? This was filed on his behalf.
Ms. Burbine, let me ask you this.
Yes.
The Commonwealth asked for a continuance, correct?
I don't know, Your Honor. I don't
Isn't
think
it
we
in the
did.
docket?
I think.
Previously. That isn't- I think it's
Previously,
in the
there were a number of continuances with, by agreement prior to this. And so there just wasn't one. There were a number of them.
Let me ask you this.
Yeah.
Suppose that we that we rule contrary to your position, that the judge has discretion to determine that the defendant has waived his right to be present, but that the Commonwealth that the motion has to be heard, at least in a case such as this, where the Commonwealth has the burden because it was a warrantless search. What if it were a case where the Commonwealth doesn't have the burden? Would that make a difference?
Well, I think an additional problem here is that the defendant came back. He only even pursued this motion because he didn't pursue it until he was apprehended a year later. So that, I mean, we don't even have him coming in the day after or a week after saying, I messed up. He took off and never pursued this until he was caught again.
Yeah,
which makes
wasn't that he was caught again? It wasn't clear
egregious.
exactly from the brief.
I'm not sure.
It
It's
doesn't
not
say.
clear.
It just says, yeah.
It just says he was in the sheriff's department.
But if his reason for not being there was the birth of his child, then...
Which doesn't appear in his motion to reconsider. I don't know where that came from.
Even assuming that, A week later, a month later, he would have been available to come
Right, and he
forward.
didn't. The only reason why this got revisited was because he was apprehended. So basically, you had a judge and witnesses and defense counsel and the prosecutor in the courtroom, and he just chose not to show up, and then apparently fled, and only when he's apprehended does he want to submit again to the jurisdiction of the court and take advantage of the court and say, okay, well, now I'll pursue this. And so I don't think that the judge in this case especially acted outside of any discretion in finding waiver, because he actually did reconsider it.
But don't we resolve that by saying, okay, you go forward, Commonwealth, on this day, which was the appointed day, in the absence of the defendant?
But I don't think you can do that where the defendant, chances are, is going to come back and say ineffective assistance of counsel for going forward because I had a lot to say about this.
Isn't
I was the
ineffective
only one.
assistance because the court has awarded it?
Well, I wasn't able to, contribute to my defense because, geez, I had all this great information about what really happened in that
But he
room.
had notice
I'm the
and
only
he
witness
waived it.
besides the police. I wasn't there. How can you go forward without me? That's
Because
the
he
danger.
waived his right to present his evidence. If he had notice, if it's on the record that he had notice, then he just chose not to be there.
Is there anything in this record that indicates that the defendant had given a reason to the judge, explained to the judge why he had not attended the scheduled hearing?
The record that I have, and my brother indicates there was a hearing. I don't have a transcript of the hearing. So the record I have is simply the filing of the defendant that he would asking for a motion.
I've seen
the
the
motion to
transcript because
reconsider.
I was the single
So
justice,
I'm
so
afraid
I've seen the transcript of
I'm
the
afraid I
hearing.
don't know because I didn't realize there was a transcript. There's no reference to it in the docket, and I didn't have it in my
Ms. Burbine, you're
information.
proceeding under Mass Law Criminal Procedure 13D2A, you
Yes.
say. And what precisely does that say, because it's not attached?
It says
to
within
the-
7 days after pretrial motion filed, I didn't attach it because I quoted it, within 7 days after pretrial motion filed, the clerk shall schedule a hearing, but a judge for cause shown may entertain the motion at any time before trial. So the judge can hear the motion any time before trial, which is what happened here. He entertained it twice. But
He didn't entertain the motion
well,
before trial.
to hear the motion, I'm sorry. So he actually did that twice here. He gave the defendant an opportunity on a motion to reconsider to present why, as I said, what the criteria should be. Was it filed on the defendant's behalf? Yes. Did he have actual notice? Yes. And what's his reason for not appearing? And he has no valid reason. There is no reason why he couldn't have appeared. It's just his own personal choice, and he should be held to that
And why would it not be
choice.
appropriate to say that he has waived his right to be present? He has a right to be present. He may need his bail revoked, that's separate. But why would it not be appropriate to say he has waived his right to be present, that provided that his attorney shows up, his agent, and the attorney elects to go forward, can the court...
Well, that would be in variation from Espinoza and McVicker, which said it's a waiver of the motion by the defendant, that his conduct constituted a waiver. And I also cited a number of cases in which the court has said, even in the situations where there are constitutional rights at issue, a defendant can actually waive those rights by his conduct, and that's exactly what happened here.
But
he chose not
if we
to
accept
appear.
what the Chief Justice said, we can't have the defendant's attorney electing whether to go forward because he would always elect not to go forward. And if we don't accept your position, what would be wrong with a rule that if the defendant files the motion but doesn't appear with notice, he has waived his right to go forward and the Commonwealth may choose to go forward?
So an automatic waiver?
No,
I'm
it's an
sorry.
automatic waiver of presence.
Of presence in the
Not of the
because I
hearing.
still think the danger is that he'll be claiming he wasn't given a right to participate in his representation because they went forward without
You
him.
can always waive your constitutional right, and a court can determine that provided you had notice and provided that your attorney was prepared to go forward, you've waived it.
Well, I would just urge the court to consider our position on this, that he deliberately gave up his right and he should be held to that decision.
Thank you, Mr.
That's good.
Irvine.
Thank you.
We'll take a short break.
All right.